When we think about the granting or creating of rights in civil law, or the denial or withholding of rights in civil laws, it's usually because of membership in some group defined by one of the following six properties: age, income or wealth, religion or creed, gender or sexual orientation, ethnicity or education. So I'm going to talk about two examples, specifically women's suffrage and the attempt to deny civil rights to people of color in the United States. And I'll focus in both cases primarily on the United States, but I'll also talk a little bit in the case of women's suffrage about the development of that right through civil legislation in countries around the world. The first modern countries or protectorates to allow women to have a general right to vote were British colonies. The Pitcairn Islands passed legislation granting the right to vote to women in 1838. 1881 saw the Isle of Man follow suit. New Zealand and the Cook Islands passed legislation granting the right to vote to women in 1893. Australia passed legislation granting women voting rights in 1902. In Australia, however, only some states allowed women to hold elected office, and neither right extended to Aboriginal women in many of those states. 1906 saw Finland, 1913 Norway, and Iceland and Denmark in 1915 ratifying suffrage laws extending the right to vote to women. Towards the end of World War I, we see Canada, Russia, Germany, and Britain pass suffrage laws extending the right to vote to women. Though I should note that in Britain, you had to be over 30, and the right to vote did not extend to women in Ireland. This is Susan B. Anthony. So when we turn to the history of women's suffrage in the United States, it's a slightly more complicated issue. The procedures and eligibility for voting, even in federal elections, are determined by state and local governments. And so there was a tremendous amount of variability. There was a sort of constant theme throughout both the colonial period and the early United States, namely that women were denied the right to vote almost without exception. Those who were given the right to vote, especially early on, tended to be men who were white, who were landowners, or otherwise taxpayers. Those were the people who primarily were the people allowed to vote, both in the colonies and in the early states. Now, historians recognized Lydia Chapman Taft as the first legal female voter in the colonial United States. After the death of her husband Joshua, she was allowed to vote in 3 town meetings in 1756 on votes that were related to the town's participation in the French Indian War. She essentially served as a proxy for her underage son, who inherited all his father's property, as women who were married surrendered their property rights. It's worth noting that her son would have had no vote, as was common at the time, if the family weren't landowners or taxpayers, and he wasn't male and white. Now, attempts to develop civil legislation that would grant the right to vote, as well as improve property rights and child custody rights, rights to access to education. The first serious attempt to do this in the United States was organized by Lucretia Mott and Elizabeth Cady Stanton, and it was called the Seneca Falls Convention on Women's Rights. It was held in 1948. And there, Elizabeth Stanton met Susan B. Anthony, where they formed a lifelong friendship and activist partnership. The next Civil Rights Convention for Women was organized by Lucy Stone, Paulina Kellogg, Wright Davis, and Abby Kelly Foster. They worked with some locals to organize the National Women's Rights Convention of 1850. Now, these conventions helped to organize and define a women's rights movement, but there was no significant progress made towards encoding women's rights into civil legislation until much, much later on. And in fact, during the period between 1850 and 1870, political unrest associated with the Civil War, as well as disagreement over the 15th Amendment, fragmented this foundling women's rights movement into two different groups that had slightly different aims. So Susan B. Anthony and Elizabeth Cady Stanton founded the National Women's Suffrage Association, which was devoted exclusively to forwarding legislation, passing legislation that would enshrine women's suffrage in civil law. And they formed this organization in 1869. Lucy Stone, however, founded the American Women's Suffrage Association, which would work towards the passage both of the 15th Amendment as well as women's suffrage. Now you might wonder, well, why was there this fragmentation of the women's rights movement in association with the 15th Amendment? Well, the 15th Amendment passed in 1870, and it dictated that certain individuals would be granted an unrestricted right to vote. And the text itself reads, "The right of citizens of the United States to vote should not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have power to enforce this article by appropriate legislation." Now, this amendment was written and interpreted to apply to men. And as such, it wasn't understood as granting suffrage to women. In fact, the 15th Amendment was part of three Reconstruction amendments that attempted to create rights for the newly freed slaves after the Civil War, but that didn't really address the condition of women at all. Votes on a women's suffrage amendment, which would eventually be the 19th Amendment, failed in 1915, twice in 1918, and in 1919. And by talking about votes and their failure, in order for an amendment to be ratified by the states, it first has to pass both houses by a 2/3 majority. And so the women's suffrage amendment failed to pass 15, 18, twice, and 1919. Now, in May 1919, the measure did pass both houses with the required margin. And then by the summer of 1920, Tennessee ratified the 19th Amendment, and that gave the 19th Amendment the necessary 36 states so that it could be added to the Constitution. And the 19th Amendment reads as follows: "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation."